If you are an employer with at least 50 employees, you should watch this video because the Department of Labor's actions in 2024 have highlighted that FMLA is a hot topic. Last year, the DOL demanded that employers pay 344 employees $1.48 million in back wages resulting from FMLA violations. And that was not from targeted FMLA actions. Those were actually discovered in wage and hour actions. So what did the employers do wrong? Well, 115 were improper denials of leave. 109 were improper terminations based on FMLA leave, and 40 were failures to return employees to the same or equivalent positions upon their return from leave. So I hope those numbers got your attention because while the FMLA is a pretty straightforward federal law, there are lots of ways employers can get tripped up and lots of ways employees can make administration of this leave very challenging. So first, let's cover which employers are actually governed by this law. The Family and Medical Leave Act is a federal law that requires employers who have at least 50 employees to provide unpaid leave to eligible employees for certain qualifying conditions and events. The 50 employee number is calculated by the average number of employees you have in a 75-mile radius for at least 20 weeks of the previous year or the current year. So if you hit that number, federal law mandates that you comply with this law. So now let's discuss which employees are eligible for this leave. Employees must have worked for your company at least 12 months in total, including any breaks in service, and at least 1,250 hours in the 12 months preceding the need for leave. So finally, let's cover which conditions qualify for this leave. They are the birth of a child or placement of a child with the employee for adoption or foster care, to care for a child, spouse, or parent who has a serious health condition, the employee's own serious health condition that makes the employee unable to work, and reasons related to a family member's service in the military. So what happens when an employee requests leave like this? Well, first, it's important to know that an employee does not have to expressly state to you that they want FMLA leave to be entitled to it. The rule of thumb that we use for our clients is if any employee requests or will reasonably need 3 or more days off due to a medical condition, or for any of the reasons I stated previously, you should consider the FMLA. In fact, you're obligated to consider the FMLA. So the first step we use for this is a leave of absence request form. I'm going to pop that on the screen here so you can see what it looks like on our end. This form also allows us to determine if the employee is eligible for leave and starts to give us an idea of whether their leave may qualify. For example, if the employee states they need the time off to care for their cat after the cat's surgery, we know that's not an FMLA leave. But if they say they need time off to have knee surgery, we know that likely that will be covered under the FMLA. If the need for leave is medically necessary, the next step we use is to send the notice of eligibility and rights and responsibilities, the employer's FMLA policy, and usually the certification of healthcare provider for employee's serious health condition or the certification of healthcare provider for a family member's serious health condition. Generally, the next form sent is the designation notice stating that whether or not a leave is approved or denied under the FMLA. I will go into specific information about each of those forms in a different video. There is a lot to cover there. I want to spend the rest of this video talking about common violations you can avoid. So number 1, forgetting to offer FMLA. Generally, this becomes a problem when you're ready to terminate an employee for excessive absences and you never offered FMLA. So technically, their protection starts right from that point. It also can be a problem with things like employees out on workers' compensation leave or those that you try to use a company policy of less than 12 weeks for their absence and don't take the FMLA into consideration. So for example, you say, we only offer 6 weeks of unpaid leave, but you're not thinking about the fact that FMLA requires up to 12 weeks or more depending on the need for leave. The solution to that is having a clear system for handling leaves so that you're checking all the right boxes. Number 2, failing to chase down those certifications. This can feel like an unsurmountable task at some point in the process. You are required by law to give the employee 15 days to return these, and that becomes even more challenging if they're already out on leave before the cert is due. Sometimes this can result in employers giving up and either improperly denying leave or providing too much leave. So the solution for that is to set up follow-up reminders and don't back down on those. Send letters in the mail with receipts, not certified mail, but a receipt of mailing to confirm that you're providing notice to the employee and you need the certification returned, plus the consequences of their failure to do so, which is likely a denial of leave. Number 3, mismanaging intermittent leave. This happens when employers don't properly track the leave, which generally results in the employee taking advantage of using it for 3-day weekends, or the employer improperly denying the leave completely because they don't understand this may be required by your policy or could be required by another law that could concurrently govern that leave. Solution is to work with your payroll vendor first to see if they can set up a pay code or another method for tracking the FMLA automatically in your payroll system. If that's not available, carefully track all hours used so you can determine when the employee hits the 480 hours allowed under the FMLA. Number 4, improperly denying leave due to a hardship that you can't prove. It's very easy to say you can't afford to have your best salesperson out for 12 weeks. It's another thing to prove that that is a hardship, and that burden is on the employer. It's not an easy threshold to meet. So my solution for that is I recommend you always seek legal counsel, legal advice from an employment law attorney before denying leave for this reason. Number 5, managers retaliating against employees for taking leave by treating them differently. Even if you have an employee you suspect is abusing FMLA, it's so important not to give them a reason to believe you are retaliating against them. There are clear protections for employees who are entitled to FMLA leave, and retaliation is always going to be the most painful penalty for employers. The solution for that is train your managers to communicate with you about any concerns they have regarding that employee's performance, attendance, or any other issue with the employee on leave or those who are returning from leave. Make sure your managers understand that it is absolutely critical they treat them fairly and courteously throughout the process. Okay, wrapping up, here's what we covered. Number 1, you should have a structured process to handle FMLA requests and train managers on them as well. Number 2, use the model forms provided by the DOL to request certifications and determine eligibility and qualifications for leave. Number 3, respond to FMLA requests immediately and in the right way without emotion, and that really is for your managers. No eye rolls when the troublemaker employee requests FMLA. Number 4, I think, know when FMLA applies, even if the employee doesn't say those magic words to request it. And number 5, be careful when denying leave under the FMLA. Seek counsel unless it is very clear that the employee is not entitled to this leave. At the end of the day, FMLA compliance doesn't have to be a nightmare. Stay organized, stay informed, and treat employees fairly. If you do that, you'll likely be able to avoid fines, lawsuits, and a whole lot of headaches.